Let me go ahead and kick things off. It's 101. My name is Andy Jimenez on behalf of the Aegis and FIA team. I just want to welcome everyone to our webinar today on navigating First Amendment audits. It's 101. I'm still seeing some people jump on. So let's give them a minute while we wait for more people to jump on. I want to take the opportunity to welcome our FIA members, and given the importance of the topic that we're going to be discussing today, we did open up this webinar to both members and non-members. I wanted to thank the Florida Association of Special Districts for their support, also for them sharing the invitation and encouraging their membership to join the webinar as well. I do recognize most of the names that I'm seeing on the webinar, but for those that are not familiar with FIA, we are a governmental insurance trust that's organized under Florida Statute 624.4322. And since 2011, we have been providing property and casualty insurance, as well as other risk management services like loss control to 1,200 local governmental entities, and that includes 900 special districts. And I promise that's the extent of my 30-second commercial. And the only other promise I'll make is that we're not going to be talking about artificial intelligence today, because I think we can all use a break from AI-related presentations. But let's go ahead and get started. One of the advantages that we have by working with so many special districts is that just due to the volume of claims and inquiries and the conversations that we have throughout the year with district managers, board members, district counsel, that really gives us a unique vantage point into the exposures that special districts and other local government entities are that are impacting them, or those exposures that could potentially impact them in the future. First Amendment audits have been around for a very long time, but it was not until maybe about 3 years ago when we started seeing that special districts were becoming targets for that. So I think personally the reason why is that most people don't understand what a special taxing district is. They don't realize that they're local governmental entities. I'm sure everybody on this call knows that, but the normal person in the street doesn't really know that. So I asked Mike and David of Roper Townsend Sutphin to put together this presentation for you guys. In the interest of time, since we're now at 104, I'm going to skip the formal bios. Mike, David, I hope you guys don't mind, but I will say this, that Mike and his team are extremely knowledgeable and experienced. They have been working with local governmental entities for a long time. This is what they specialize in. They are a member of our panel council, and I've had the opportunity and I would say pleasure of witnessing firsthand how passionate they are and how they have successfully defended some of our members against some pretty nasty and complex claims. So with that, I'm going to be monitoring the chat and the Q&A. Mike, David, if you guys want to take it from here.
All right. Thank you so much, Andy. Thanks for the kind introduction. Good afternoon, folks. As Andy has indicated, we're going to be talking about First Amendment audits today. Just to sort of give you an idea of what we hope to cover is we want to give you a general outline of the nature of the activity. Some of the folks on the call may already be familiar with what we're talking about, but some folks may not have had the pleasure of dealing with one of these situations before. We're going to outline the applicable law in this area, and then hopefully give you some practical strategies for how to deal with these individuals if they appear at your district and you have to deal with them down the road. I think just as a practical matter, it's important to note that the reason we're talking about this today, and Andy touched on this, is that the failure to handle one of these encounters properly could certainly result in a number of different avenues, but most importantly, I think for our purposes today, it could result in civil litigation and potentially a liability exposure to the district but also because we're talking about federal law and federal implications of this activity. It could result in the individuals themselves being named as parties in the lawsuit, the folks that are involved in dealing with these auditors, and could be named in the lawsuit. So for your own personal interests, it's certainly, and for those of your staff, it's important that we understand the constitutional parameters of what we're dealing with. Andy said earlier in his presentation that these audits have been around for a long time. They have been for many years, but in terms of constitutional law, they're fairly new phenomena. They really sort of have their genesis in the Rodney King situation that was several years ago, many years ago. The incident itself and the video that was taken of that incident sort of has given rise to additional case law in this area. As Andy says, though, it's certainly becoming a more widespread activity. I think primarily because of our culture of social media and the desire to monetize social media content. I think in terms of the prevalence of these visits, if you have not already had the pleasure of encountering one of these First Amendment auditors, I think you can say that the probability is that you will likely have to do so sometime in the future. So with that being said, as a background, just to get started, the first question is basically, who are these folks? Okay. I think, one school of thought is that they're constitutional activists. Another school of thought is that they're, citizen journalists, or modern cop watchers. Okay. Those are I think those are the categories that they would place themselves in. I think perhaps other folks might suggest that they are people who are anti-government and looking to antagonize government. And then, of course, as I mentioned earlier, with respect to social media, whether or not they're seeking to post these on their various websites. The term, First Amendment auditor is sort of a strange term, but that's what they call themselves. And essentially, what they do is they record government officials and employees. They record in or on government facilities in the public, and the basis for their activity is that the courts have recognized that there is a First Amendment right to film public officials in public places. And that, as far as it goes, that is an accurate statement of the law. Where the disagreement comes in is the auditors have incorrectly, in our estimation, conflated public property and public buildings with public places. Essentially, they contend that the term public places means all public property and not just streets, sidewalks, or traditional public forums. So that's kind of where the disagreement comes in. What do they do? Well, what they'll do is either, as a single person or as a group, they will descend on your district offices. They'll be unannounced. They'll just walk in with a camera, and they'll be filming. They often start filming while they're still outside the facility. They'll initiate contact with your staff. They'll refuse to identify themselves. They'll refuse to state the purpose of their visit or the context of what they're doing. They'll indicate that they're, filming for a story, or they're with the citizens press or something along those lines. They're often, at least initially, they're not confrontational initially, but as soon as they encounter any resistance, they often become very belligerent, condescending, and they tend to interrupt you if you're trying to talk to them. They demean whoever they're talking to. You don't know what you're talking about. This is federal law. Don't you understand what law applies here? And they threaten lawsuits, obviously, if they don't get their way. And clearly, this sort of activity, which comes out of the blue with no warning, it's alarming for your employees. They don't know what to expect, and really what we need to do is try and equip them with the information about what is and is not allowed, and the ability to respond appropriately to one of these audits. If someone's going to interview you, I mean, just the fact that you're on camera, it can be very disconcerting for an individual. If someone's going to interview you for a traditional news story, they'll tell you, this is what we're going to ask you, and this is how we're going to do it, and you'll have some idea. But these folks are, just sticking a camera in your face and asking, what's your name? What do you do? Can I go in that door? Those are the kinds of activities that they sort of spring on your unsuspecting staff members. The question then is, why they're doing that. And I think, as I said, there are certainly some of them that contend that they are performing a public function. Essentially the term First Amendment audit comes from the context of them, their position is that they are testing the government. They're testing to see whether or not the government is going to recognize constitutional protections which apply to the First Amendment, and that's why they're conducting an audit. It's a pass-fail scenario for the governmental entity. Once again, I think that if you just go on the internet and type in First Amendment auditor, you'll see any number of these websites that will pop up. And honestly, I would encourage, especially the folks that are in a position where they are likely to have to deal with this, either as a as person in the front of the facility who's greeting the public and dealing with the public, or a manager who may be called to the front to have to deal with one of these situations. I would encourage you to take a couple hours or so to just kind of scroll through some of the videos that are online, because they're quite eye-opening, and I think they would help prepare you for what's potentially involved in this situation. What I'm going to play for you next is a video, and I warn you in advance. It's a little long. It's about 6 minutes long. I cut it down as much as I could, I think the reason I want to play the video is it goes back to that old adage about a picture being worth 1,000 words, and I think it would be helpful to everyone on the call to see an actual example of one of these encounters, and quite frankly, how quickly they can escalate into something that's quite unpleasant for your staff. Before I play this video, I want to stress that it's not my intention in any way to embarrass any of the public employees that are depicted on this video. They're certainly doing their best, and perhaps just aren't equipped with enough information. But I think this video would properly fall into the category of essentially what not to do in one of these situations. And sometimes, as I say, we learn best from seeing the practical application of this, and seeing other folks perhaps mistakes or incorrect judgment. So before I start the video, I'll just describe briefly what happened, what happens before we start the video, and that is It's one of these First Amendment auditors. They've walked into City Hall. At the point in time that they walked in initially, the front office person is dealing with another customer. So they just sort of wander around the facility and they're filming, just stuff on the walls or pamphlets and that kind of thing. And then the customer leaves, and that's where this video picks up essentially.
Like, just confirming we have the audio on the video as well. Not hearing it on my end.
You're not hearing it on your end, Andy?
No.
Let me see here. Okay, let me try that again. Let me go forward and. Okay. Are we hearing it now?
Yes, can hear it. Thank you.
Okay, sorry about that.
Thank you so much. Hey, can I help you?
Yep, just taking some pictures and video.
And you're with,
I'm sorry?
and you're with,
The Free Press.
okay.
States 1 and 2 up for election. Candidates run at large. June 25th. Election. How you doing? Let's see if I can do a public records request. Florida Statute 119. Are y'all familiar with that one?
Public records request.
Yeah, it's a real easy one.
Public records request form. One second, let's see if we got one.
Hi. Yeah, it's really easy. Is the lady in the black there? Is that Elaine?
No.
No. Oh, what's her name? Is it Hayden?
You spoke with her, did she give you her name?
Well, I didn't ask her. Can you I mean, what's her first name? It's public record.
What's your name?
Well, what's her name?
What's your name?
Are you not a public? What's your name, ma'am? Are you a clerk or what are you?
I'm just me.
You're just me. So you're going to refuse the Florida Statute 119? I'm giving it to you verbally. The law prescribes I can give it to you verbally.
My name?
Yes, I do. Yes, you do.
No, I don't.
Yes, you do. You're a public servant.
What is your name?
You're a public servant. Betsy. I gave you mine. You're not going to give me yours? Betsy, no?
Excuse me?
I already told you my name.
What did you say it was?
Betsy.
Betsy?
What's your name?
Renee.
Renee? Okay. And what's the lady in the black? Is she going to identify it?
If she would have wanted you to,
Is she elected official?
ma'am,
Is she an elected official? It's very simple.
West form?
I'm giving it to you. Yeah, I'm giving it to you verbally, as the law prescribes.
There's your form.
Okay, is Elaine in then? Can I speak to Elaine, please? And what's your name, ma'am?
You need to leave.
No, what's your
No,
name?
you need to leave.
Florida Statute 119.
I'm gonna call law enforcement.
You can do what you need.
Affecting our normal operation.
I'm asking you what your name is under Florida Statute 119.
Harassing us.
No, I asked you what your name was, ma'am. You're a public servant.
Walk out that door.
Florida Statute 119. Florida Statute 119, public records request. I would like your name, ma'am. It's that simple. What is your name? I mean, how hard is that? I already told her my name.
And I already told you to leave.
I would like your name, ma'am.
Okay, can y'all send somebody down here? She's like staying here at the window,
Trying to get service.
harassing my staff. We can't even do our job.
Trying to get service.
No, you're not trying to get served.
I asked you, public records request, Florida Statute 119. You're not familiar with it?
Okay. All right, thank you. All right.
Elaine?
Ma'am, they want you to leave the premises.
And if I don't,
City
what happens?
manager.
I'm sorry?
City manager.
All I wanted was her name. I asked her what her name was, sir.
Well, that's up to her. She wants you to leave.
Well, under public records request.
So come on. You can do that some other way.
Well, I'm asking her, see, it's called a Florida Statute 119.
Asking you to leave right now.
So if I don't leave, what's going to
You're
happen?
going to be arrested.
Okay, that's all I need to hear.
Okay?
Under duress, I'll leave.
City manager wants you to let
That's number 2. So is it from in here or here?
From,
You know these are federal lawsuits, sir. You swore to uphold the Constitution. I'm trying to get service. I tried to get service. Because you don't, because you're a public servant. I'm not, sir. I'm trying to get
Quit
service,
following me
sir.
around.
It's public, sir.
No, you ain't gonna
It's
walk up on,
public.
you're not gonna walk up on me like that again.
I'm sitting there
Okay.
I'm trying to sit there and talk sense
I'm
into
not
you.
talking to you.
I'm
You are-
talking
you
to
are-
you.
You are to leave the premises.
So this property?
That's right.
Okay.
Per the city
Well,
manager.
okay, I'm heading that way.
That's right.
Well, per
Go
you.
ahead and go.
Okay.
All right?
Under threat of arrest, I'll leave. That's number 2, sir. That's 2 federal lawsuits you've earned.
Do their job.
Well, if they did their job, they would have answered my public records request. Florida Statute 119.
That's between you and them, not me.
You just trespassed me from public. From public. From public. Wow, Lake Butler. Tyranny. This is the face of tyranny that our founding fathers warned us about. Right here. Right here. See the POW MIA flag? Round 2. Second time. Boo Lake Butler. Absolute disgusting. Disgusting. This is it. This is the face that our founding fathers warned us about. This right here. And the sheriff's department is the one who's supposed to uphold the Constitution. You failed. You failed your own.
Okay, so we can, a couple of points about that video. I guess the first point is technically the so-called public records request that the auditor was making is not an appropriate public records request under those circumstances. The public records law allows you to request records or documents. She was asking for information. She was asking for the city manager's name. So, in terms of the propriety of that request, that's certainly questionable as to whether or not that was a proper public records request. And we can discuss it as we go through the presentation in terms of how that was handled. But, the city manager chose in that case not to provide her name. As I said, you don't have to provide information necessarily, but under the circumstances, if she's a city manager, certainly in terms of that information being, public information and something that's readily out there, the question is whether or not she should just answer the question and diffuse the situation. So we'll talk about that as we go through the presentation further. Okay. So First Amendment auditors, as the name suggests, the basis of these claims is the First Amendment. Importantly, all of your districts as political subdivisions of the state of Florida are subject to the First Amendment and the other protections contained in the Bill of Rights. As a result, there are certain restrictions on governmental activity which would be otherwise perfectly acceptable in the private sector. So in the private sector, if someone came on your property and was filming, you could tell them to leave. That's not necessarily the case in terms of the public sector. The other thing that's a little bit odd is, the concept of that a video recording of someone is a form of speech. That's a somewhat unusual concept. However, as I indicated, that's where the courts have placed this protection. and determined that it is protected speech, both the recording and then the subsequent transmission of that recording. Importantly, the First Amendment also protects freedom of the press, which is why, and they did in that video, these auditors will often refer to them as members of the press or journalists. They're trying to cloak themselves in the protection of the First Amendment. As I said earlier, I mentioned the Rodney King case earlier, and the courts have recognized that under the First Amendment there is a constitutional right of citizens to gather information about what public officials do on public property, and specifically a right to record matters of public interest. It's the concept sort of was crystallized in the context of law enforcement citizen encounters, and that there's a right to record and photograph police activity subject to a reasonable time, place, and manner restrictions. That's the law in that area has been established for certainly a long time. And it has sort of morphed from the police and citizen encounter to the type of encounter that you just saw in that video. Importantly, the First Amendment does have limitations and doesn't guarantee you the right to express your views in all places in all manner that may be desired. And we'll talk about a little later in this presentation about the different type of forums that exist and the different analysis that might apply to each forum. But there's not an absolute right, and sort of where we're talking about and where this discussion really focuses on is, with respect to its property, the government does have a right to preserve and control the use of its property for the use to which is lawfully dedicated. Okay, so there's not, whereas, and we'll talk about with a forum, but the forum, the being on the street or being in a public in a traditional forum is a lot different than being in a building, a lobby of a building, or in interior parts of a district building. So some examples of the right to record under the First Amendment, as we talked about, clearly established that recording police citizen encounters, providing not interfering or obstructing with the officer in the performance of his duties, recording at public meetings, which are subject to the Florida Sunshine Law, that's a protected activity. Other activities which are not protected, for example, are filming in a jail or a secure area of a governmental building. Example here, there's actually a case on this, standing in the median of I-95 and taking video. That's not a protected activity. As I say, the restrictions on recording require an analysis of the forum in which the analysis, where the speech is taking place, okay? And there really are four separate forums that need to be considered. The first one is a traditional public forum. The second is a designated public forum. The third is a limited public forum. And then the last one is essentially no forum whatsoever. It's a non-public forum, and there's no forum there. And at that point, I'm going to turn it over to David, and he's going to kind of go through that analysis with you with respect to each one of these different forums. Okay. So David, I will click to the next slide and I'll let you jump on in.
Okay, thank you, Mike. Do want to go back to one thing with the whole issue of standing in the median filming a car accident. I came in that case was Crocker versus Beatty, and I came in on that case kind of towards the end when it got appealed to the U.S. Supreme Court, and the court obviously didn't take it up. But technically, I think Beatty was able to show a First Amendment violation or a Fourth Amendment seizure when his phone was taken from him. But that the court held that, it wasn't clearly established at the time that he couldn't, or that, law enforcement couldn't seize him when he was standing in the median. But, so that's funny because some of these cases, Mike and I have worked on in the past. But, going forward, though, when it comes to government property and these First Amendment auditors, typically they're kind of broken up into different forums. And the first one is the traditional public forum, which is if you've watched any old movies and you see people in the movies, they're standing on, the soapbox in the middle of the town square, giving the news, right? And so that is typically what we think of when we think of traditional public forums. So these are government properties or government controlled properties that are traditionally held in trust for the use of the public and time out of mind, have been used for purposes of assembly, communicating thoughts between citizens and discussing public questions. So again, the modern day examples are going to be public streets, parks, sidewalks, Speaker's Corner in Hyde Park, London. I think some of the cities still in this country have like designated like boxes where people can get up and give stump speeches of any kind. And so that's what we think of. We think of traditional public forum. The communication, the free flow of ideas, among the citizenry. And, a citizen has, I guess you could say, the strongest amount of rights available in the traditional public forum. And the ability of government to regulate speech in this type of forum is extremely limited. And just being honest, if a government wanted to limit speech in this kind of forum, there's only a handful of examples, and they're usually really extreme, so, to like illegal content, if that makes sense. So the restrictions that are permitted usually when it comes to time, place, and manner, that's usually the defense is that, we're not restricting your speech then on viewpoint-based discrimination. So our restriction then is content neutral. So for example, usually you can say, okay, well, you can have any kind of sign you want, but all signs must be less than 2 by 4, right? Something done 2 feet by 4 feet. That would be considered a content neutral application or restriction on speech in a public forum. But then the restriction also has to be narrowly tailored to serve a significant government interest and leave open ample alternative channels of communication. So again, the content of the sign, not really something you can restrict, but okay, not everyone can carry a giant billboard maybe in a public park. That might be excessive. You have to have a smaller sign, and courts are more likely than not to find that to be an applicable or appropriate restriction on speech, as long as you're not targeting the content or the viewpoint being expressed from the speech itself. So the next we have what's called a designated public forum. Mike, you go ahead and click the next slide. There you go. And so a designated public forum is government property that has not traditionally been regarded as a public forum, but it's intentionally opened up as a forum to the public at large. It does not have the historical pedigree of a traditional public forum, and expressive activity in a designated public forum can be limited to a particular class of speakers instead of the general public. So the one example we have listed here is a public university's so-called free speech area. Probably those are kind of getting struck down by courts. I think a better example now is probably something more of like a town hall meeting, where you can restrict it to only citizens, of the town hall, right? You live in the town, you can come to the town hall meeting as open, right? And then you can also restrict, usually to the topic that's being presented or discussed. And then our next one would be called what's called a limited public forum. And so this one is where the government has reserved a forum for certain groups or topics. It cannot be open to the public at large for the discussion of any and all topics. Each individual member of the class must obtain permission from the government proprietor of the forum, who in turn has discretion to grant or deny permission. So some examples of this are going to be public comment portions of meetings, relevant to whatever the government's discussing, or things like, public university sidewalks, a mall, or rotunda. Another good example of this, again, could be like a city hall or a city planning meeting where time is then limited to citizen comments for, a minute. Each person gets to speak for a minute. If there is some sort of advanced warning to the public, okay, we'll allow you to speak, but it has to be related to what we've discussed today, and you can't use profanity. Those are probably kind of general rules that would be allowed, because the government is announcing the rules in advance. We're limiting the public forum to this topic and this kind of speech. And again, that's what we have as our last bullet point. And then so the last one is kind of a non-public forum, or there's no forum. And that's where the government acts as a proprietor and manages internal operations. So things like this would be like restricted areas in government buildings, even if they're not like a jail, for example. If it's just an office building and then there's like an area in the front, maybe open to the public for public business, and then the back is, for employees only, that would be considered a non-public forum. The public's not, allowed to go to this area. But definitely things like bathrooms, locker rooms, you just can't film there. There is an expectation of privacy. And then facilities, they may have protected information. So for example, some public health departments, people are there, they're there because they're sick, or they're there because they have, they're exchanging or dealing with protected health information. That would be an area that would, not be a traditional public forum. And then definitely things like, jails or holding areas, probably police stations, at least, once you try and leave the, the open foyer, the front, police or sheriff's offices would also qualify. And the restrictions here, the government or the courts have allowed higher restrictions, and you really, almost any restriction is allowed unless it's arbitrary, capricious, invidious, or viewpoint based. So the government has much more leeway in those types of settings. So unfortunately, the analysis for these is a little more complex than I'd like to admit. And so to determine the type of forum, you have to consider what physical characteristics are of the location. What is the property traditionally used for? What is the government's intent and policy concerning the usage? Is it the presence of any special characteristics? Is it, law enforcement related? Is it health related? Is it, what's the property designated as? Are you using it to hold town hall meetings? Or is it a place where people just only come to pay bills or get information? And then the property's compatibility with expressive activity. If, next to City Hall, you have a giant park and people are allowed to protest there, it may be more difficult to have more restrictive, measures there. And you have to consider all the factors when establishing rules or regulations. No single factor is usually dispositive. And then a government does not create any type of public forum by inaction or by permitting limited discourse, only by intentionally opening up a non-traditional forum for public discourse. And government-owned or operated property does not become a public forum simply because members of the public are permitted to come and go at will. So one of the, the video that, Mike gave, for example, is not a traditional public forum in the sense it's a government kind of business office where people come in and get records or can request records or conduct business with the government. Now, on the flip side, this is something that happened a couple of years ago in 2017. The University of Florida had an area on campus that had a stage and performances were held there and speakers were allowed to come in and give speeches. The problem was University of Florida had obviously opened this up as a limited public forum, and a gentleman by the name of drawing a blank on it, but he was involved with the Charlottesville incident in 2017. Richard Spencer has his name. He's a white supremacist of some sort, and he wanted to come speak at the University of Florida. And initially, the university denied him because they're like, no, we don't want your kind of speech here. And then there was a lawsuit that was threatened or filed, and the university had to capitulate because the only restriction they had was viewpoint-based discrimination, and the court, frowns upon that, even if it is highly disfavored speech that people don't like, or it's an extreme level of speech, it's still viewpoint-based. So there has to be usually conditions given in advance that aren't viewpoint based in order to prevent speakers or to create a limited public forum. All right, so common places for First Amendment audits.
David, do you mind? Sorry, before you jump to the next one, there is a question that's related to the forums. We can go back to that slide.
Sure.
So the question is regarding, and I have a feeling a lot of people that are on have a similar question, which is really regarding non-public forums. Is there signage required for employee-only areas? They don't have signage. Are they able to access points within centers unrestricted? And to expand a little bit on that, I would say that some of the members, the people that are on right now, may have questions regarding employee break rooms, storage warehouse. Do they have to identify early on or have signage basically making these restrictive spaces? Right.
Yeah, Andy, and this I am going to address that in the section in terms of the practical application of the things that they can do. But yeah, I mean, it's not absolutely required, but it's certainly best practices, because then that gives both the auditor and the employee a clear designation of the public versus non-public areas of the facility.
Perfect.
Right.
Thank you.
And then I think also, from what I've seen, just in real life, experience, a lot of the areas that are not open to the public, even if there's no sign, it's very obvious. There's a badge you have to swipe to get in, or a key code you have to punch in. And I think, a court would look at that and say, okay, yeah, obviously it's not open to the public. The public doesn't have, the 4-digit pin to get into this doorway or this hallway, something that's, secure. And I think a break room would also apply in that sense. So moving forward, some of the common places for First Amendment audits, like we saw in that video that Mike showed, are going to be lobby areas of government buildings, pretty much anywhere where someone can just walk in and start filming, or they're filming already. And so the distinction then is, limited public forum or is it a non-public forum? Typically they'll try and, walk down hallways, and they'll try and go to some areas like offices, workspaces for government employees. In my opinion, these are non-public forums. The interior police departments, again, non-public forum. The interior polling places, non-public forums, but it's important to point out though that there's a different answer though for streets and sidewalks that are adjacent to polling places. Public hospitals, also again, non-public forums. Public schools are a little different because, in my opinion, if the school is in session or there are children there, it's a non-public forum, but then schools oftentimes open up their facilities after hours or on the weekends for other expressive activity. For example, here in Orlando, there are some churches that use school auditoriums on the weekends for Sundays services. Sometimes town halls can occur in like school gymnasiums. So I think there has to be a clear designation for when the school is being used, for school purposes versus, okay, we're going to let the public come in to do something else. And then courthouses, of course, are also non-public forums as it pertains to filming. Now, if there is a trial or something else going on, the public is allowed to go in there just to observe as long as there's room. But then generally though, these types of things are handled by the judges in the courtroom themselves.
All right, so,
Oh, sorry.
I'm sorry, David, are you finished with that one?
Yeah, I'm on slide
Okay.
20 now.
All right, so I think the takeaway from all of that is the location of where you encounter that First Amendment auditor is important. Okay, and I don't necessarily think that we need you to take away from this presentation, all of the specific legal ramifications that we discussed, but just to understand that encountering an auditor on the sidewalk, walking into the building may be different than encountering them in the lobby. Okay, so that's just one consideration. Obviously the auditor will have additional protections if it's in a traditional public forum as opposed to in a lobby, which is either a limited public forum or a non-public forum, depending upon what court you're in front of. But the sort of the ultimate conclusion is that at least within the common public areas of your facilities, the lobby areas and that type of thing, your staff is going to be subject to being filmed. If they're up front and they're dealing with the public, and they're in an area which is generally open to the public, they're generally going to be allowed to be filmed. Okay, you can limit that, but the limitation has to be reasonable, and we'll talk about that in a second. But bottom line is they need to understand how to deal with these folks if they encounter them. The fact that they're annoying or distracting, doesn't divest them of their First Amendment rights. They certainly can't disrupt the business operations, and that's kind of where where the government has a little bit of a wedge. And they certainly can't prevent employees from going about their work. But they don't have to be civil. They don't have to be pleasant. They just can't be disruptive. Remember, they're looking to instigate a confrontation. This is for clicks ultimately at the end of the day, and social media content. And if they can't provoke a reaction, the likelihood is that they'll go away. There's not much fun watching someone just act calmly and responding to the questions and telling them what they can and can't do. That's not going to generate content for them. Okay. The one area that's kind of interesting is courts have recognized, and in particular, a court here in Florida, a federal court here in Florida, has recognized that, because governments have the ability to place reasonable restrictions on filming in limited public forums, in areas of the government offices which are open to the public. There was an ordinance that the city of Punta Gorda enacted, which basically prohibited video or audio recording at City Hall without the consent of those being recorded. And that would be anyone present, whether they're an employee or the public. And the court found that was a reasonable restriction. And the rationale for that decision is that if you continue to record people who didn't consent to that, that would constitute a disruption of the city's business operations. I think it's important that within that decision, the court talked about the fact that one of the reasons the ordinance was reasonable was that it didn't entirely preclude recording within the public places of the agency, because the auditor could have filmed, so similar to the fellow or the lady, excuse me, that was filming the pamphlets that were in the city hall, in the lobby where she was. They could have filmed other parts of the public places. They could have also filmed persons who did consent to being filmed, and so they weren't entirely precluded. And so that's certainly an avenue for local governments to consider if they want to consider adopting some sort of regulation or rule to that effect. There are a number of governmental entities that we're familiar with that have adopted that type of a regulation. And there are certainly model ordinances online, and we can certainly share those with you if anyone is interested. But understand that it's likely going to attract attention and potentially pushback from these auditors, because that certainly has been the case with other cities that have adopted that type of an ordinance. But at this point in time, at least in the Middle District of Florida, that an ordinance of that nature has been found to be to pass constitutional muster and be a reasonable limitation. There are other courts, not in the 11th Circuit and not in Florida, which have found that a complete prohibition on video recording in a limited public forum is reasonable. But in our opinion, that would be potentially problematic for you to completely prohibit filming in a limited public forum. All right, so, and this goes, I think, to Andy's question, or the question that was brought up earlier in terms of strategies for handling the auditors. I think the first and most important thing is to do your own audit, do your own review of your facilities, and harden them in the sense of making sure that they are properly marked as far as public and non-public areas. Okay. And there's no magic language in terms of how that should be done, but visible signage, indicating something to the effect of restricted access, employees only, employees and invited guests only. Those are the types of things that I think would be relevant. Note that it should be on all potential access points into the building. These folks will walk around the entire building. They will go to the back door. They'll go to the side door. If it doesn't have a sign on it, then they'll presume that it's not a controlled area, not a non-public area, and they'll attempt to get in. Okay. Obviously, and I think David mentioned this before, physical access controls, keep the doors locked, have some sort of key card or controlled access. And then obstructing the views with blinds or window tint. That seems like maybe going above and beyond, but I will tell you, they'll stick the cameras right up against the window and try and film inside of offices. Those are the types of activities to expect from these folks. All right, so to the extent you can harden your facilities, that's a good idea.
Thank you.
Okay, so I'm going to play this video now. This is an example of hardening your facilities. This is actually part 2 of an audit that was done initially before this facility had posted signs, and then after the facility had posted signs. And I will tell you, generally, these auditors will respect the signage. If it's posted as being a non-public area, they will respect that. Okay, or restricted area, they will respect that. So this is kind of an example of a entity that went back and placed signs and it clearly designated what areas were public and non-public.
Thank you for
Oh, there we go.
Doesn't look like any signs back then.
They have since
Oh, good.
put authorized personnel only. Isn't that funny? Here. So, I don't need to spend any more time.
No signs there either.
Have a good day.
All right, you too, please.
So he's talking about this right here. See how it says restricted area?
Jim was wrong here too. No signs on this side of the building.
Employees only beyond this sign. Watch. Restricted area, employees only beyond this sign.
Nothing on this corner either.
These are new signs. These were definitely not here before.
I don't see any signs over here on the left side of Dennis, over there between the tree and the pole.
Okay, so there's that. Okay, so, but I think ultimately, really the best way to deal with these folks is to make sure that your front office staff are trained and know what to expect and know how to know what your rules and regulations are, have a clear understanding of those, and know how they're expected to respond in the event an auditor comes into your building. Okay. The main, and I know that I've said this a number of times, but it really is the key here is to stay calm and avoiding confrontation, because that's what they're looking for. They're looking to provoke a reaction. You need to make sure the employees understand where recording is and is not permitted, and any other applicable rules in the facilities. And by that I mean, for example, if there are rules regarding disruption of work, that type of thing, they need to be aware of those so they can be confident when they're dealing with these auditors. They need to be familiar with the public and non-public areas of the workplace. You may want to consider having a designated person to respond to an auditor. You saw that in the video that I showed, the initial lady that was having to deal with this individual was sort of deer in the headlights. I mean, she really didn't quite understand what to do. Now, one thing I would suggest is the person that you designate to respond to the auditor is not someone who's going to escalate the situation, but someone who's going to de-escalate it and respond to it in a calm fashion. You need to, your folks need to anticipate that the recording will be on the internet. I mean, a lot of times these people are live streaming. So I think, for example, in that first video I showed, I think they were live streaming. They need to be able to respond in providing simple and consistent instructions to the auditor in terms of what's allowed and what's not allowed. They don't need to debate or engage with with questions and answers with the auditor. As I said before, the so-called public records request was really a request for verbal request for information. It wasn't a true public records request. So there really was no reason, no legal reason why the city manager had to respond to the question of what's your name. But and it's probably best not to engage with these folks as much as possible. Your staff needs to be prepared that they're going to be interrupted. They're not gonna get a chance to speak. They're gonna try and these folks are gonna try and talk over them. They're gonna try and demean them in terms of, you don't understand the law, you don't know what you're talking about. They're gonna really try to antagonize them, and they need to be prepared for that in advance. They obviously don't want to in any way try to restrict the auditor's activity with respect to viewpoint, in terms of what, the viewpoint that they're trying to get across. Obviously don't touch them. Likewise, don't let them touch you. And then, sort of, if the situation escalates and to the point where it's either becoming disruptive, you feel unsafe, you feel threatened, then, it's certainly appropriate to contact law enforcement and have them deal with it. But as I say here, I think that truly is, the last resort if you want to try and deal with it yourself, because with law enforcement, oftentimes comes some type of custodial situation, and that's where that often bleeds into litigation. We talked about this before in terms of ordinances, so I won't cover that again. One thing I do want to mention, though, is in a number of the cases that we've handled, the auditors, when they come in, they've got profanity written on their, they've got a T-shirt on that has some sort of profane phrase or writing on it. Okay, that's intentional. They're trying to trigger some type of reaction, and I think it's important to sort of not fall for the bait on that. Understand that there are certain particular protections for the use of profanity. The most well-known case is that case out of California. I think it was back during the Vietnam War, the court essentially said that particularly for political speech, there is First Amendment protections. Now, that doesn't mean they get to come in the office and swear and carry on and be disruptive. There are certainly reasonable limitations that can be placed on that. But just, if they've got something written on their on their shirt or their clothing that's profane, to the extent that it's not overly disruptive, the best thing is to try and ignore that and not make that a focal point of your decision how to handle them. Let's talk about the importance of an appropriate response. I mean, first of all, as you can see, the video is likely going to be posted on the internet, and there's the sequelae associated with that. It may attract attention from traditional media. It may get picked up, by one of the reporters on your local station, and as a matter of public interest, and maybe broadcast on that. Obviously, it could result in some type of an official complaint that's being made by the auditor. But here's really where the most important issue is, and that is, litigation. Okay. And commonly, what the claims that we see in these types of cases are, if an alleged First Amendment violation, or a claim that you retaliated against them for exercising their First Amendment rights. If law enforcement is called in response to the scene, you could have the potential for false arrest claims, and that would be against not only the officer, but also the individual who instigated the arrest by calling the officer there in the first place. So they potentially could be named in that type of a lawsuit, and the agency could be named as well. We've got excessive force and battery claims that could arise out of an arrest, a malicious prosecution claim as well. And there are a number of other types of claims that could be brought as well. Okay. The importance here, and I think really is, you might think, okay, well, if the guy's arrested, obviously that's one thing, but if they're just asked to leave and they leave and they're not arrested, what sort of damages could there possibly be, and why is that a concern? Here's why it's a concern. Number one, litigation in Florida in recent years has resulted in some crazy verdicts per se. Secondly, it's important to note that with respect to the federal claims, the federal claims are not sort of the traditional personal injury type claims that we think about in terms of, you get a percentage, the lawyer gets a percentage of what they recover for the claimant. Okay, we're familiar with the, we're all familiar with the plaintiff's lawyers that appear on TV and say, you don't pay anything unless we win, that type of attitude. Okay, with respect to federal claims, the recovery of attorney's fees is not based on what the amount of money that's actually recovered in damages for the injured plaintiff. If in a civil rights case, if the attorney prevails, let's say he only gets $10,000 for damages for his client, he's entitled to have his attorney's fees paid based upon the amount of time that he has spent on the case, multiplied by a reasonable attorney's fee. Okay, so we have cases where really the driving factor in the case is not the recovery that the plaintiff is going to get. It's what the attorney's fees are on that case. So it's kind of like the tail wagging the dog. You've got you've got a case where potentially the exposure for damages to the plaintiff may be $5,000 or $10,000, but the potential for the attorney's fee award is like $200,000 or more. Okay, and that's a difficult situation to be in because if there's a clear violation, then they're going to get their attorney's fees. So that's the real concern about these cases that we have as lawyers representing districts and other governmental entities. Okay, so last thing I'm going to do is I'm going to play a video of a person who did it the right way and handled it like we would like to see these types of things handled. Okay, so this is once again someone going to City Hall. You can see that they start filming when they're still outside City Hall. So I'll just play the video and we'll take questions at that point in time.
Hey, good afternoon, everybody. As you can see here, it's a beautiful day here in Gainesville, Florida. Thank you, everybody. We go check it out. I've actually never been in this City Hall, so it'll be a first for me. Everybody tickle that like button, subscribe button if you're not subscribed. Make sure you hit that notification bell. That way you never miss an episode. As you can see, this place is pretty big. It's a pretty big City Hall, 4 floors. So it's sitting right downtown. I'm not sure if I'm gonna have to go through security or not. If I have to go through security, y'all just make sure you tune in, because sometimes when I go through through the screening process, sometimes my phone cuts off, but I'll be back live if it cuts off, y'all. I'll just let you know. How you doing? Good. Y'all have a big building here, huh? What are we doing? Taking some pictures. You're live right now. Say hello to everybody. No, you're gonna be a star.
Let me find out.
Find out. What are you finding out for? This is City Hall.
Yes, I know.
Oh yeah. You talking to the mayor?
No.
Oh, can we talk to the mayor? I'd love to talk to the mayor. No? Are they camera shy?
Well, I don't know, man.
Oh, okay.
Walking around with a camera and everything throughout the building, and here, and I don't know if that's allowed or not, or whatever. I know she said City Hall,
Okay. Oh yeah. Can I go in? Is this publicly accessible?
she's gonna come out and talk.
Oh, okay. Is this publicly accessible? Oh, okay.
Hi.
Hey.
This is the City Commission offices.
Oh, sure.
Kristen Bryant, I'm
Okay.
with the City Clerk's office.
Nice to meet you.
Yes, hi. The public spaces.
Oh,
are
yeah.
The lobby and the steps and the,
Oh yeah. I'm only going to some publicly accessible areas.
okay,
All right. Nice to meet you.
nice to meet you.
You too. Is the mayor available to talk to, or?
No, he's not in at the moment.
No,
Our
aw.
mayor and our commissioners are part-time only.
Oh, okay.
So.
Do they work from home or they work here?
They work here. They
Oh,
work
okay.
offices.
I didn't know if with the COVID thing they would work at home, or if y'all were still doing it. So.
No, yeah, we're.
Oh, okay.
they're in
Good,
the
good.
offices.
Excellent. All right. Thank you so much.
You're welcome.
Uh-huh.
All right, so obviously on that, obviously the gentleman up front had not been prepared to deal with the situation, but he at least knew enough to go get the right person. You notice that in terms of the questions that the auditor was asking, is that area publicly accessible? They're trying to they'll try and push the envelope, but clearly that was designated as a private area. There were locks on it, and so they handled that appropriately. The lady that came out, showed him where the public areas were, didn't try to interfere with his ability to film, and that ultimately ended in a nothing incident and I guess a pass from the auditor of that agency. We do have one other area that David's going to cover real quickly, and that is social media, and it's not, it's a little bit off topic, but the concepts are the same. And I know this is an important issue to many of you.
Yeah, so I've worked on some of these social media issues in the past. And it's important to remember the forum doctrine still applies. It's a little bit simpler than in the physical realm. But the main thing to keep in mind is it really is dependent on whether it's a personal account or an official account. Some of you may remember, Donald Trump was embroiled in some litigation a couple of years ago because he was tweeting from his real Donald Trump page, which was his personal page. But then when he became president, I believe the court found that he was communicating official government policy from it. And so he couldn't then block people from accessing it. And, the same still applies for any other government agency. If you have a Facebook page or a Twitter page or an Instagram page, there's a case that I kind of did some work on a while back called Robinson out of the Fifth Circuit. And Robinson, a sheriff had a publicly available Facebook page and they were deleting certain comments. Oh, hold on. My light sensor clicked off. They were deleting certain comments on the sheriff's Facebook page that were critical of the sheriff. And this person sued the sheriff, and the Fifth Circuit Court agreed with the person suing the plaintiff and said, yeah, once the government opens up a digital forum like this, you cannot then, based on viewpoint-based discrimination, you can't just delete comments that you don't like. However, there was another case involving Sheriff Darnell out of Gainesville, I believe, where she had opened up a Facebook page, but had publicly posted on it that only comments related to law enforcement and without profanity will be allowed, or something to that extent. And people got comments deleted that didn't follow those rules. They sued, and the 11th Circuit held, well, hold up, because the government posted in advance that this was not an open public forum, that they were going to delete comments that were, not involved with the guidelines, reasonable guidelines established, that it's a limited public forum, therefore those, rules are allowed, and therefore the government can delete comments or block people, I think, that they find to be, inappropriate. So it's important, if you have social media pages up and running, that you either have a disclaimer in there saying, okay, here are the rules, keep it respectful, no profanity, keep it to, issues related, no spam. But, if you've already opened it up and anyone can post on there, unfortunately, then it becomes a public forum and you can't delete comments based on, content you disagree with.
Only one thing I would add on that is that, you can shut down the forum altogether, correct? I mean, you can decide that, hey, we're going to shut down the forum and stop it, just not have it anymore.
Right.
Okay. All righty. That's everything that we've got for today. And as I said earlier, if anyone's interested in those ordinances, we're happy to share those with them, and happy to take any questions that we may have.
Okay. Perfect. All right. So I know we ran a little bit long, but really appreciate you, Mike and David, going over this. It was extremely interesting. I think in particularly the towards the end, the social media part of this could itself be its own webinar. So spoiler alert, that could be very well our next topic that we discuss. I know that this is a really big exposure or issue that sometimes community development districts have with the resident-run boards. It's a topic that comes up quite often. I know that we're running late, but we'll take one question. I appreciate everybody that stayed on. Just about everyone has stayed on, even though we're now about 15 minutes late. I apologize about that. But the one question that came up, I think you guys were talking about it's lobby cameras filming in City Hall. Do people have to sign a consent when they come in? And I think that question came up when you guys were talking about the Punta Gorda case.
Okay, so do other citizens have to sign a consent form?
Yeah,
Or
I think if the district or the local governmental entity have security cameras,
yeah.
and they're recording the public that comes in, do the people that come in have to sign a consent form before they come in?
No. I mean, you know, it's recognized that that is a reasonable security measure. In fact, that got brought up in that Sheets case, the Punta Gorda case. Essentially, they said, well, what the plaintiff said was, well, hang on a second, you're stopping me from filming, but you've got security cameras all over the lobby here. You're filming these people. And the court said it's apples and oranges. You know, they're allowed to have those cameras for security purposes, and it doesn't mean that the restriction was not reasonable.
Okay. Interesting question that came in. If an auditor is confrontational or disruptive, can we film them with a personal cell phone?
There's no prohibition against that. You know, the one area that might be problematic is if, you know, if it's just, if we're operating under that consent ordinance that we talked about, and the auditor says, I don't consent to being recorded, then you've got a conundrum on your hands, right? But yeah, because, you know, I don't think there's anything wrong with that. I mean, you're essentially documenting potentially for future litigation, the nature of their disruptive conduct. And so once again, you're not being disruptive. You're just simply preserving that, because God knows they're not going to, if that's the case, they're not going to preserve that evidence themselves, right? That'll be deep sixed at some point in time.
Yeah. Now, another, just to follow up on that question, is now with that video that was taken by a government employee or agent, or, you know, or elected official, is that now subject to public record? Is that a public record?
It would likely be a public record, yeah, because it relates to the operation of the business, and yeah, it would likely be a public record.
So any sort of retention law and policy would apply to that video as well?
It would, and if it's taken on your private cell phone, you'd want to make sure that's transferred pretty quickly over to the public server, and delete it off of your cell phone.
Okay. And okay, so the last question was, does ordinance trump law? And I think this came in when you were talking about, you know, having ordinance to kind of harden or, you know, mitigate the risk that you may have from these claims.
Yeah, no. I mean, a local ordinance would not trump federal law. Okay, all the ordinance would do is establish a reasonable restriction on filming. It's not, you know, so ultimately, you know, federal law and the First Amendment and the principles associated with the First Amendment would control, but the ordinance gives you that reasonable limitation or restriction on their exercise of their First Amendment activity.
Okay, sounds good. Oh, so with that, I will say one thing in closing, Mike, is that for maybe not for us, but for most people on this call, the Rodney King case was a long time ago. All right,
point
again,
well taken, Andy.
So David, Mike, again, thanks. This was extremely interesting. I know that I learned a lot from this as well. And for those that are still on, I appreciate you guys staying on. We'll make the recording available and we'll share that through the link. I know some people had a hard time seeing the first video. We'll share the link for that video as well. And again, thanks for joining us, and please be on the lookout for future webinars. Thank you.